Every concealed carry permit in America is suddenly being questioned. The Supreme Court just ruled the majority opinion is out. The dissent is furious, and states are already moving to exploit every single word in this decision. What you're about to hear could change how you carry, where you travel, and how you protect your family. If this is new to you, hit subscribe right now because this story is moving fast and you can't afford to miss what comes next. We're looking at a 6-3 decision that was supposed to settle the law. Instead, it opened a Pandora's box of legal liability that puts everyday gun owners in the crosshairs. The headlines are calling it a win, the fine print says something else, and the shock waves hitting gun owners right now are not what most people expected. Everything you thought you knew about the right to carry outside the home just shifted. The details inside this ruling are not what many gun owners were anticipating, not even close. States are already rewriting their laws, the DOJ is already preparing to enforce the new framework, and millions of Americans who believed they had a settled, protected right to carry are now facing a legal reality that's more complicated, more expensive, and more dangerous to navigate day to day than many in the gun rights world are publicly admitting. Every major Supreme Court ruling has two layers. There's the headline that spreads across social media and then there's what the opinion actually says once you read past the first paragraph. Most people never get past the headline, and that's exactly how rulings like this can do the most damage, quietly buried in legal language nobody reads while everyone else celebrates or panics over a summary that misses the point. Court's 6-3 majority opinion does affirm that Americans have a right to carry firearms outside the home. That part is real, that part is true. But buried in that same opinion is something gun owners, gun shops, concealed carry instructors, and Second Amendment advocacy groups are going to be dealing with for the next decade. The ruling explicitly preserves and in key ways expands the government's authority to define, regulate, and restrict the manner, location, and conditions under which carrying can legally occur. Think of it like a map. For decades, you had a general sense of where you could go. You had your permit, you had your firearm, you had your rights. But this latest High Court decision just redrew the borders without clearly marking where the lines are. According to constitutional law analysts at the Cato Institute, the opinion contains no fewer than 17 distinct categories of location-based restrictions that the majority signals as constitutionally permissible. 17 categories: schools, government buildings, hospitals, public transit, bars and restaurants, sports stadiums, places of worship, polling locations, parking structures, parks, public demonstrations. The list, in the opinion, is not exhaustive, it's illustrative, meaning states can add to it. And here's the number that puts that into devastating perspective. According to a 2024 analysis by Everytown for Gun Safety, if every location category named or implied in the opinion is implemented as a restricted zone by a maximally restrictive state like California, New York, or Illinois, a concealed carry permit holder in a major American city 4:004 minutes could find that over 80% of the spaces they move through in a daily routine are legally off limits. Over 80%, a right that exists on paper but can't be exercised in real life is not a functioning right, it's a legal decoration. Since this ruling dropped less than 48 hours ago, over 50 state attorneys general have issued emergency guidance to law enforcement, over 50 different interpretations of the same document, and a meaningful number of those interpretations are restricting access, not expanding it. Federal Concealed Carry Authority, the legal power you thought you had to protect yourself in public, has never faced this level of coordinated bureaucratic pressure in American history. According 484 minutes, 48 seconds improper carry under new state guidelines has doubled since the news broke, with no sign of slowing down. And here's what most people have no idea about. The majority opinion includes a footnote, just one footnote, and what it chose to say because of that footnote has essentially never happened before in modern carry law. The phrase sensitive place has never existed as a defined legal term in any federal law, not once. It was coined by state legislators precisely because it sounded flexible. That's not an opinion. Legislators who helped popularize the term later confirmed publicly that the label was chosen for bureaucratic impact, not technical precision. And today, every state that restricts carry uses a different definition. California uses one list, New York uses another, Illinois uses a third, New Jersey keeps rewriting its definition every few years to capture more and more locations. A restaurant that's completely lawful to carry in Texas can become a felony zone in California, not because it's more dangerous or has different security, but because it serves alcohol or has a playground nearby. A 2023 study by the UCLA School of Law found that over 500 specific types of locations are banned in at least one state but completely legal in others. Same building, same function, different zip code, totally different legal status. Under the new framework, the government must show a clear, consistent historical tradition for any restriction it wants to defend. But if the definition of what you're banning changes by state and by year, you can't show any consistent tradition at all. The case collapses before it even gets fully litigated. And what makes this even more volatile? No two state governments have ever agreed on a single unified definition. That means the foundation of location bans in America is built on a term that has never meant the same thing in two different places at the same time. According to a spatial analysis published by the Second Amendment Law Center, if all currently proposed sensitive place legislation in the 5 most restrictive states is enacted and survives initial challenges, a permit holder in New York City could have legally permissible carry locations covering less than 8% of the city's publicly accessible geographic area, less than 8%, and carrying in a sensitive place, even accidentally without any criminal intent, is a felony in most of these jurisdictions, not a misdemeanor, a felony. The Second Amendment was written over 200 years ago. Do you think it still applies to modern concealed carry laws the same way it did back then? Tell us your honest opinion in the comments, because the answer might determine your legal future. For years, the concealed carry permit process in America has been a patchwork. Some states required minimal training, some required none, some issued permits broadly to anyone who qualified under basic standards. The gun rights community largely accepted it because permits were obtainable, relatively affordable, and once issued were often recognized across state lines through reciprocity. That era is ending. This ruling by affirming government authority over the conditions of carry has effectively handed state legislatures a green light to overhaul permitting requirements in ways they believe can survive constitutional review under the new framework. The question is no longer whether states can require training. The question now is how much training can they mandate before a court says they've gone too far, and the honest answer right now is nobody knows. That boundary hasn't been fully litigated yet, which means states with aggressive anti-RE legislatures will push that line as hard and as fast as they can, and gun owners will pay the price while courts slowly sort it out over the next 5 to 10 years. Here's the data that makes it real. California has already introduced legislation requiring 16 hours of live fire range training, a psychological evaluation, an in-person interview with law enforcement, 3 separate background checks at the state level, and a $350 non-refundable application fee just to apply. Not to receive a permit, but to apply. Maryland is moving towards similar requirements. New York's legislature is debating a proposal requiring applicants to submit 5 years of social media history as part of screening. According to a 2023 survey by the U.S. Concealed Carry Association, the average cost to obtain a concealed carry permit in a shall-sue state is currently $95 in a may-issue state operating under aggressive new requirements. That cost is projected to exceed $800 to $1,200 once training mandates, psychological screenings, and application fees are fully implemented. That's a $1,000 price tag on a constitutional right, and here's what makes it even more consequential. According to Pew Research Center data from 2023, Black Americans represent a disproportionately high share of new gun buyers and first-time permit applicants over the last 4 years, many motivated specifically by personal safety concerns in urban areas. The financial architecture being built around carry permits in the wake of this ruling will hit these new gun owners hardest and price them out fastest. The people most vulnerable and most in need of protection are about to face the highest bill to exercise a right. Poll taxes on voting were struck down, but nobody has successfully argued the equivalent doctrine for the Second Amendment yet, and until that case is won, states can charge what they want. But the permit process isn't the only place this ruling opens a dangerous door, because what the court said about revocation should stop every gun owner cold. Under this new regulatory authority, the opinion affirms that states are moving towards systems where a permit can be suspended or revoked, not because you committed a crime, not because you were convicted of anything, but because an administrative body, a licensing board, a law enforcement agency, a mental health review panel decides you no longer meet the state's carry criteria. No trial, no jury, no criminal standard of proof. A 2022 report from the Johns Hopkins Center for Gun Violence Solutions found that 12 states already have some form of administrative revocation authority operating independently of the criminal justice system. Post-ruling legal scholars at Harvard Law School have written that the constitutional door is open for more states to expand these systems. If your permit can be revoked by an administrative panel without a conviction and if carrying without a permit in your state is a felony, then a bureaucratic decision made without a trial can create the conditions for a felony charge. The pathway from law-abiding citizen to potential felon runs through a government office, not a courtroom, and this ruling widened that pathway. Do you believe a government agency should be able to revoke your carry permit without a criminal conviction? Drop your answer in the comments right now. One of the most practically important features of America's concealed carry system has been interstate reciprocity, agreements that allow a permit issued in one state to be recognized in another. If you have a Florida permit, 37 states honor it. If you have a Utah permit, 34 states recognize it. Reciprocity has allowed millions to travel, work, and move without losing the ability to legally carry. This ruling created the conditions to break that system. Here's why. Reciprocity depends on rough equivalence, the assumption that a permit issued under one state's standards is broadly comparable to a permit from another state. Once states begin to diverge drastically in requirements, and this ruling gives them incentive to do exactly that, those agreements start to crumble. A state that now requires 16 hours of training, a psychological evaluation, and a $1,000 process has no legal or political reason to honor a permit from a state requiring 4 hours 95. According to the National Conference of State Legislatures, there are over 1,400 individual reciprocity agreements between states governing concealed carry recognition. Legal experts at George Mason University's Anton Scalia Law School have warned that post-ruling regulatory divergence could render many of those agreements functionally obsolete within 3 to 5 years. What that means for the 22 million permit holders in this country: a right you lawfully obtained and paid for at home could become legally invisible the moment you cross a border. That is not a national right, that's a local permission slip. Here's something almost no ordinary citizen knows, but it shapes nearly every federal gun law ever passed. Commerce Clause, the part of the Constitution that gives Congress power to regulate trade between states. For decades, Congress used it as the quiet justification for everything from background checks to the original federal assault weapons ban. The argument was simple: guns cross state lines when sold, so Congress can regulate them as interstate commerce. Courts accepted that for a long time without serious pushback, but the Commerce Clause grants power over commerce. It does not grant power to erase a constitutional right. A 2024 article in the Georgetown Law Review argued that after this ruling, Commerce Clause justifications for restricting commonly owned firearms are constitutionally unstable going forward. The hook Washington has used for 60 years may be pulling right out of the wall. Did you know the government has used a trade regulation clause to justify gun control for decades? Does that change how you view federal gun laws? Tell us in the comments. For 50 years, gun control won in court through interest balancing, putting your rights on one side of a scale and public safety on the other, then letting public safety win. That scale no longer exists in Second Amendment cases. The new framework abolished it explicitly. This ruling reinforced it. The Supreme Court stated clearly that interest balancing has no place in Second Amendment analysis. Your right to own commonly available firearms does not get weighed against government safety concerns. It exists as a constitutional right. And here's the data point that makes this shift brutal for carry ban defenders. The CDC's own published research found restrictive carry laws showed no statistically significant reduction in overall gun violence during their existence. According to the FBI's Uniform Crime Report, concealed carry holders of all types are involved in approximately less than 1% of all gun homicides annually. The statistical case for singling out concealed carriers has always been thin, and now under the new framework, it's legally irrelevant because courts aren't allowed to weigh statistics against constitutional rights. But here's the scenario that will play out hundreds of thousands of times in the next several years. A law-abiding citizen with a valid concealed carry permit, no crime, no intent, unknowingly enters a newly designated sensitive place in a state with aggressive post-ruling legislation. They didn't know about the designation past 6 weeks ago. There was no sign posted at the entrance. They're now committing a felony. This isn't hypothetical. It's the predictable consequence of building an ever-expanding network of location-based carry restrictions without an infrastructure for clear public notice. A 2021 study in the Journal of Criminal Law and Criminology found that among individuals charged with firearms-related offenses in New York and California, a meaningful percentage had no prior criminal history and reported genuine ignorance of the specific restriction they violated. They weren't criminals carrying illegally, they were permit holders caught in regulatory complexity they didn't know existed. As sensitive place designations multiply, as state laws diverge, as permits and reciprocity change, the density of this legal complexity becomes impossible for ordinary people to navigate. No reasonable permit holder can maintain a constantly updated mental map of every gun-free zone in every jurisdiction they pass through, but the law will expect exactly that. And when they fail, not because they're dangerous, not because they're criminal, but because the legal architecture has become too complex to navigate without a lawyer, the consequences are catastrophic: felony charges, permanent loss of gun rights, a criminal record, all for an honest mistake. This is the shock. The 6-3 decision was supposed to clarify. Instead, it complicated. It handed states a new playbook of delay, It turned routine interactions into constitutional disputes and shifted the burden onto you to know the law better than the officer writing the ticket. The victory is theoretical, the risk is practical, and for the next 5 years, every time you holster that firearm, you're gambling on whether your state decided to comply with the Supreme Court or fight in the shadows. In a 6-3 ruling, the 3 dissenting justices don't control the outcome, but what they write in dissent matters. Dissents often become the blueprint for future majorities. This dissent didn't argue that concealed carry should be banned, it argued that the majority's historical tradition test is unworkable and should be replaced with a more flexible standard that gives governments more room to restrict carry. That argument isn't going away. If the court's composition shifts by even one justice, that dissent can become tomorrow's majority opinion, and if the historical tradition test is weakened, every gain gun rights advocates have made under the current framework could be unwound. 4 of the 6 majority justices in this ruling are over 65. Gun owners treating this as a permanent settled victory are making the same mistake gun control advocates made in 2008 when they dismissed Heller as inconsequential. No Supreme Court ruling is forever. Every ruling is a snapshot of one day's majority. Has the Supreme Court become too powerful in deciding gun policy that should belong to elected legislators? Drop your honest thoughts below. Here's what the gun rights advocacy community isn't saying loudly enough. The states that lost the broad carry argument didn't lose funding, didn't lose legal teams, and didn't lose political will. They lost one battle in a war they've been fighting for 40 years, and they're already pivoting with more resources and sharper strategy than ever. Every town for gun safety, the primary institutional funder of gun control litigation and legislation, reported a budget of over $100 million in 2023. Following this ruling, its leadership publicly committed to channeling much of its resources into sensitive place legislation, defense permit requirement expansion, and administrative revocation framework development. Ford's Law Center had model sensitive place legislation ready within 72 hours of this ruling. That's not reactive, that's preposition. Meanwhile, legislators in the most aggressive gun control states entered their sessions with bills already drafted, waiting for exactly this ruling to provide the constitutional hook to move them forward. They aren't scrambling. They were ready. According to the NRA's Institute for Legislative Action, at least 23 pieces of state legislation expanding carry restrictions under the new framework were introduced within 30 days of the decision. The counter-movement isn't coming, it's already here. The Second Amendment Foundation reported a 40% increase in litigation funding following the recent rulings. That money is deployed and aimed directly at carry restrictions across the country. Under the new framework, the burden sits on the government to prove a restriction has historical grounding. That burden doesn't get lighter because you rewrite the law more carefully. If you're still banning commonly owned firearms, you still don't have the historical analog. The trap is the same, no matter how polished the new wording is. According to the Firearms Policy Coalition, more than 40 active federal challenges are already running simultaneously against existing bans. The litigation wave isn't approaching, it's in motion right now, and here's what almost nobody is connecting. If the Commerce Clause justification fails in court, it doesn't just threaten carry restrictions. It potentially threatens the foundation of dozens of other federal gun control measures that have never been seriously tested, possibly all at once. Inside a legal environment where historical tradition is the test and the government may not have the history to point to, courts have always allowed narrow regulations with clear historical backing, background checks, restrictions for convicted violent criminals, certain location rules. Those survive because history supports them, but banning carry in most public spaces that has no historical backing, not one documented law from the founding era, not one from the 19th century, not one from 200 years of tradition that banned an entire class of commonly owned functional firearms from public life the way modern laws attempt. We're entering an era of legal fragmentation where your rights depend on which judge you get, which county you're in, and which way politics blow that week. This is not the stability gun owners were promised, it's volatility, and it demands vigilance. You can't just carry anymore, you have to study, you have to track, you have to be ready to defend your rights in court long before you ever have to defend yourself on the street. There are over 22 million active concealed carry permit holders in the United States, 22 million people whose legal status under this framework is now subject to a regulatory system being rewritten in real time differently in every state. What was valid yesterday may not be valid tomorrow. Where you carried last year could be a felony location next year. The permit you paid for may not be recognized across a border it was recognized across 6 months ago. And legally, financially, safely navigating all of that is now your responsibility because the system being built around your right is designed to make navigation as difficult as possible. The Constitution doesn't bend for politics, but regulations built around rights can squeeze those rights until what's left is barely recognizable. What you just heard is not a prediction, it's a description of what's already in motion, already funded, already moving through legislatures and courtrooms right now. There is a path forward. It requires organization, it requires funding, and it requires staying informed, because if you wait until you're handcuffed to learn about this ruling, it's already too late. The next ruling could change everything. The next legislative session could close the next door, and the only people caught unprepared will be the ones who stopped paying attention after the headline told them they won. If this opened your eyes to what's actually inside the ruling, share it with every gun owner you know. Hit like, drop your honest thoughts in the comments, and subscribe right now, because this story is far from over, and the next development is coming faster than most people are ready for. We'll be tracking every one of these cases, we'll be breaking down every new state law, and we'll be holding the line on what the Constitution actually says. Remember, this is analysis, not legal advice. Consult an attorney in your jurisdiction.